Good morning, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket. We will hear them in the order in which they appear. Let me remind council that each side has a total of 15 minutes, and that applies whether one or multiple attorneys argue on that side of the case. The appellant also has the right to reserve up to 5 of your 15 minutes for rebuttal. So when you get to the podium, please, after you've introduced yourself, let us know how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements? Hearing none, please call the first case.
Estate of Christine Joy Koczwara versus John Beasley.
Good morning.
Good morning, Your Honors. May it please the court, Hank Fincher. I'm a trial lawyer from Cookeville, Tennessee, and I represent the appellant here, Mr. John Beasley. I would like to reserve 3 minutes for rebuttal.
Certainly, Mr. Fincher.
Thank you, Judge Clement. The parties in this case are John Beasley and the decedent, Christine Koczwara. I want to compliment the clerk for getting the name right. It's a very difficult name to pronounce, but it's well known in our local community. Both for the decedent, who is a nationally recognized artist, and her artwork is phenomenal, but also for her sister, who was a longtime teacher in our community. So the name's well known there. We're here today because of what I believe are 2 fundamental errors made by the trial court, and then several dozens of others that followed from these 2 fundamental errors. The first was the failure to hear and then grant our motion for summary judgment regarding standing on the 2020 will. The decedent had a duly executed 2020 will that left everything to John Beasley, my client. Named him personal representative, and it left everything to him.
Was a petition to admit that will ever filed or admitted to probate?
It was filed. It was filed 4 days after the complaint was filed in Chancery Court. It has never been admitted to probate. It has been requested to be admitted, but the probate court wants to see what happens with this. That's the long and short of it. But it's pending. There's also a will contest in probate court that's not been certified pending the outcome of this. Okay. So and that hints at the complications that lead to the other error, the motion for default. That was granted. It was improvidently granted. There was an answer on file. There was a pending motion to dismiss. There was a pending and well-supported motion for summary judgment based on the 2020 will and the standing.
And so did the trial court ever dispose of the motion to dismiss at any point, or just said, I'm not going to grant leave to set aside the default?
Yeah. It used the default to dispose of both the motion to dismiss and the motion for summary judgment.
So the court said, I've granted default, I don't have to consider the motion to dismiss.
Yes.
Okay.
Yes, that's the way it took care of it. 2 more errors based on those fundamental errors that happened. Regarding the motion for summary judgment, the reason it destroys standing is my friend represents his father, also a friend, who is named executor under a 2016 will. That will was revoked by the express terms of the 2020 will. The 2020 will is duly executed, 2 witnesses, prepared by an attorney. There's testimony. It's in the form of an offer of proof. It wasn't admitted at the trial in this cause, but there's testimony from the attorney who did it. It's Attorney Will Robertson, well known in our community, and he did the will. And that's in my brief, I believe in pages 51 through 54, I believe. But his testimony set out in key part in that brief.
The trial court stated that he believed there was a profound is my word, conflict of interest of the attorney because he represented your client and the decedent at basically the same time.
Yeah, he did. And with respect to our chancellor, I think he was wrong about that. I don't think there was a conflict at all because they were aiming in the same direction.
Well, doesn't the undue influence doctrine contemplate that the testator will get independent advice of counsel?
Well, the proof that's laid out, again, it's in the offer of proof, indicates that it was independent. The attorney was hearing from other people what she wanted to do. We actually presented two of those people, again, through an offer of proof, who testified this is what she wanted to do. And I mean, to me, we live in a small town, right? People represent each other. If we had to get somebody else on.
Cookville a small town. But
Well, it definitely can be. It definitely can be. And it is when you start talking about attorneys because several of us do a lot of the work. My friends do a lot of the work. I do a lot of the work. Will Robertson does a lot of the work. There's other fine attorneys, but you're talking about a universe of 24 civil attorneys that are doing wills in town that have connections in the community that we're talking about. Could she have found one? Sure, but she chose not to. She went to Mr. Robertson. I don't think it was a conflict because there wasn't a conflict of interest. Mr. Beasley's interest and what the decedent wanted to do were in unity.
Well,
they
that
weren't
presumes
conflicting.
she wasn't under undue influence.
Well, correct.
So the mere fact that she's announcing that this is what I want to do doesn't necessarily mean that's her independent will and judgment.
While I agree with that statement, the testimony from the attorney was she said it over several meetings, over several months, and had said it to other people, and said it when Mr. Beasley wasn't present. Now, had there been a trial, had the proof been there, I would submit that that proof would rebut any presumption. But I don't think there's a presumption of undue influence here, although one was applied by the trial court. I explained that.
Let's
That's a
talk
sub
about the
Yes, sir.
800-pound gorilla in the room, and that is your client didn't file an answer
Right.
for more than a year.
Right.
And the trial court found that it presented no facts that would constitute excusable neglect. So let's talk about that.
Okay. First, it was 11 months. It would have been due 30 days after the complaint was filed. I think
So it's only 10 months late. Not
10 or 11 months. The answer was late. But you have to remember there were, as we've already referenced, there were two proceedings. There was a probate proceeding going on, and there was the Chancery Court proceeding. 4 days after this complaint was filed, on December 7th of 2020, previous counsel filed the 2020 will. And in his affidavit, which is part of the record, he explains why he thought this should take care of it.
And let's be clear, when you
Yes.
say filed the 2020 will, he filed a petition to admit the 2020 will to probate.
Yes, sir.
Okay.
Yes, sir. But he filed the will with the probate court, the original will with the probate court, but correct. So the 800-pound gorilla, why did he wait a year to file his answer? Because opposing counsel waited a year to do anything, apparently, according to the record, and 10 days before previous counsel filed his answer, my friend filed a motion for default. That was granted several months later after I had gotten in the case and filed a motion to dismiss and a motion for summary judgment and served discovery and started the case down what I thought was the path towards the usual resolution. We either resolve it through summary judgment or we take discovery and we have trial.
What struck me in reading this, though, I mean, obviously, if you're going to set aside a default, you're going to say we've got a meritorious defense here in
Yes.
the case. And to me, the will itself, the later will, doesn't operate as a complete defense here, does it? Because we're talking about checks that were written by the decedent during her lifetime and to your client. And so it wouldn't be necessarily enough just to say, well, there's a will that leaves me everything, that I was going to get this money eventually. I mean, that wouldn't necessarily explain why the checks were written, and especially checks written to your client's friend.
Right. With respect, I think there's an implicit assumption there that we can't assume, and that is that undue influence happened. When the way that it operates, as I see it, and I would submit is the way the law on undue influence sees it, is number one, we have a will. its due execution, and it's presumed to be valid until it's contested. My friend would have to file a will contest, an alleged undue influence, and then come forward with facts to prove undue influence. If and when he did that, and that's the missing piece in your statement that the will doesn't matter, if and when he did that, then, okay, we've got proven undue influence, not a fictional assumption of undue influence due to a procedural default. It would have been established by proof and hearing and testimony and documents and everything else. And that's what didn't happen here. There was no proof. There was no truth in what the trial court ruled. It was all procedural, and it all piled fiction on fiction on fiction, and has resulted in a complete disregard of the decedent's intent expressed in the 2020 will, what she wanted to do and who she wanted to get it, her caregiver. You can read the testimony from her friends, her neighbors, who talk about how she loved John Beasley, how he was there, and how she brightened up because of the care the man was giving her. Now, that wasn't admitted. That was an offer of proof. It is in the record, but it wasn't admitted. That's the injustice.
Is that relevant to the motion for default?
Yeah, well, yes, because we're dealing with an initial grant of default that was opposed, at which a substantive defense was in the record. The court was on notice that we're here, we have a strong legal argument, and we have a strong factual argument that they shouldn't even be able to raise these issues on behalf of the estate. They lack standing. And because they lack standing, they can't go forward.
How do they lack standing if their will has been admitted to probate and your client's will has not been admitted to probate?
Because the later will.
The lack of standing would be just the reverse.
Well, the lack of standing comes from the revocation by the 2020 will.
Which has not been admitted to probate.
Hasn't been admitted to probate yet it exists,
So
it's there.
It's just a piece of paper.
Well, it's a will. It's a will.
It's
And
a piece of paper that has the word will at the top of it, but it's not the decedent's last will and testament until the probate court says so. But anyway.
well, I'd say so, but the probate court hasn't had its final say. It had its initial say because they got to court first, and it admitted that will. And we filed a contest that it won't certify because of this. If you look at that will, respectfully, Your Honor, it's a valid will. It's signed by the decedent. It's witnessed. Read the testimony. To disregard it is to disregard the truth of what the decedent wanted. I understand the procedural point, but it's another procedural point that should be subordinate to justice. The seal says do justice until the skies fall, not uphold procedural technicalities until the skies fall. I'm out of time.
There are certain obligations on the parties to follow procedures so that you get to the correct decisions. That's why we have the procedures.
And I'm not suggesting that we should just throw procedure out the window, but we should look at the context and whether or not it caused prejudice.
And we recognize that you were not the attorney for your client when the motion
Yes.
for default was filed.
I was not, but I sympathize with him, and I agree with everything he said in his affidavit for what that's worth.
Thank you, Mr.
Thank you.
Fincher.
Thank you very much.
Mr. Rader, good morning.
Good morning, Your Honors. May it please the court, I'm here on behalf of the estate. And as the court knows, the elephant in the room is the 1 year before any action was taken. The affidavit for Mr. Mackey sells short the efforts that the plaintiff was taking during this intervening year, but it does acknowledge them. We were investigating the financial crimes, the money that had been taken. We had issued a number of subpoenas to banks and health care providers trying to develop the evidence that we would need if the case were to be ultimately tried on the merits. So the plaintiff was making efforts to proceed with the case. It was the defendant who did not take any action for that intervening year. The trial court found it to be a key fact that at no time did the defendant, through prior counsel, ever file a motion for an extension of time pursuant to Rule 6.02. Didn't do it orally, didn't do it in writing. Of course, Rule 6.02 requires that extension to be made by motion. In this circumstance, the case law repeatedly discusses that the trial court has discretion to grant an extension of time if asked, but the trial court does not have to do so sua sponte, and did not do so. Even as we sit here today, now 4 years later, there's still been no motion for extension of time orally or in writing with respect to that answer. So what happened is the defendant, after receiving the motion for default, belatedly filed an answer the afternoon before the hearing was scheduled, and then did not show up for the hearing. The counsel did not show up for the hearing. The court didn't proceed because counsel wasn't there and had called the judge's secretary, which is certainly understandable, but it isn't an excuse. And the reported case of Looper from this court, and it quotes another case, Roche, which is a reported case from this court, I hope I'm pronouncing it right, R-O-S-C-H-E, says that the belated filing of an answer is not an appropriate response to a motion for default. Now, people come in and they move for extensions of time, and trial courts grant those. There's a standard that has to be shown under Rule 6.02, but it's fairly lenient in fairness. But that was not done here, and no attempt was made to ever make that showing that's necessary. So the court properly granted a default in that case, in this case. And it bears noting that this was not a one-off incident where Mr. Beasley didn't file an answer. As opposing counsel noted and argued during the damages hearing, Mr. Beasley wasn't participating at that stage of the case either. He wasn't cooperating with his defense. I quoted those statements to the trial court during the damages hearing that Mr. Beasley, the defendant, simply won't cooperate with by fine opposing counsel here. So it's this individual that's in default, certainly not the attorneys. With respect to whether or not this answer that was on file the day before the hearing, or even the later filed motion to dismiss or motion for summary judgment could bar the entry of a default, I think the answer is pretty clearly no. Not on their own anyway, not without asking the trial court for an extension of time. I've cited the court to several cases that this court has held that these filing of petitions and defensive pleadings after the motion for default are not sufficient on their own without the extension. The only case that I think that my opponent has really cited is an Abercrombie case, First Union versus Abercrombie. It's an unreported case. That case did not allow the default because there had been a motion to dismiss for several months before the motion for default was ever filed. In other words, the defendant in that case filed a Rule 12 motion. They didn't file an answer, which of course is what Rule 12 allows. That motion to dismiss was never set for a hearing, and sometime 4 months later, the plaintiff filed a motion for default because there was no answer.
So was there a ruling on the motion to dismiss here? I mean, was it a situation where the trial court just said, well, I've granted default, I don't really have to deal with the motion to dismiss?
The motion for default was heard first, and so that once the court granted the motion for default, at some point in the record, the trial court did rule on the motion to dismiss and the motion for summary judgment by saying that they were moot as a result of the default.
Appellant here points out, I think a valid point about the Looper case is that, it's an ouster proceeding.
Sure.
And so that does make the circumstances somewhat different here. I mean,
I agree. But there are numerous cases that we've cited and held. Looper just happened to be the main reported one on the subject, but subsequent cases from this court, the Alessa H case, the Pache Industries case, all stand for the same proposition, that it's incumbent upon the defendant, if they want an extension, to request one by motion, as Rule 6.02 requires. Now, courts sometimes allow oral motions on those. Written motion is the right way to do it. But that wasn't done in this case, and the court could grant a default.
Yeah. The overall policy, sorry to interrupt, counsel, but the overall policy for courts should be to try to decide cases on the merits here. We're not doing that based on a procedural fault on behalf of Mr. Beasley. So, I'm struggling a little bit with the circumstance here that sort of justifies this sort of drastic action.
Well, that's the kind of argument that's appropriate to make with a Rule 6.02 motion for an extension of time. Judge, you should allow my late filed answer because we did.
XYZ.
That's
yeah.
right. And apply that principle that we want to resolve cases on the merits. And if the trial court had denied that motion, then we'd be in a different posture here, and you'd be reviewing that kind of decision. But no such request was ever made, and the trial court's not obligated to sua sponte just grant extensions in that regard, especially when no explanation's been offered. When Mr. Mackey submitted his affidavit to offer the explanation was in connection with the motion to set aside the default. And the Discover Bank case from our Supreme Court says that the threshold inquiry is willfulness, whether it was willful that they didn't file an answer. In other words, the complaint wasn't lost in the mail. There was not some inadvertence where they prepared an answer but didn't get it to the clerk's office. Mr. Mackey chose not to file an answer. And what he said in his affidavit was that he was hoping that the plaintiff would just go away because he had filed this Rule 2020 will. That's a deliberate choice. And the case law very clearly says that if there's a deliberate choice, that is willful. And so you cannot set aside a default in the face of willful conduct. Even if it were not willful, and you disagreed with that conclusion of the trial court that I think is very well supported by the record, but even if you disagreed with that, as Your Honor noted, there has been no showing of a meritorious defense. The only defense was urged at that point in time was the standing argument based on a 2020 will that had not been probated and that everyone knew had not been probated and that the record showed had not been probated. Even if that 2020 will were a will and it had some legally operative effect, which I think is very clear that it doesn't, the statute 71-6-120C makes clear that the standing still goes to any interested party who is not the personal representative. So in other words, the Tennessee Adult Protection Act contemplates that this might happen, that someone as an elder abuser might go get a will as part of their scheme.
So do we have an agreement here on what the status of the filing of the 2020 will is? It was filed, petition for probate, but it was all just stayed because of the...
We filed a response in opposition to admitting that to probate and raised several substantive defenses with respect to the execution, such as the witness who purportedly signed it is the attorney who prepared it and who represented Mr. Beasley actively. And we say that that is not a disinterested witness. And we've raised several legal arguments and cited some authority to that point. And I mentioned some of it in my brief here as well. But that is pending based on substance, not just stayed.
Yeah. And so the 2016 will, everything goes to the animal shelter, is that correct?
Basically, there are a couple of small bequests to some friends or family, but...
And then 2020 all goes to Mr. Beasley.
That's right, and he's the executor and sole beneficiary.
You made reference to the Adult Protection Act, and I didn't get the essence of that. Why is that relevant?
So under that statute, under 71-6-120C, it says that if the person with standing to bring a claim is the personal representative, but if the personal representative is the alleged wrongdoer, then standing goes to any interested person. So my point is that even if the 2020 will were effective, even if it had been admitted to probate, it still does not deprive standing, and it doesn't give exclusive standing to Mr. Beasley because the statute contemplates that possibility and takes it away from him and gives it back to anybody else. So standing is not a meritorious defense, even if the 2020 will had been admitted to probate. And so there's been no showing of a meritorious defense. So even if you get past willfulness, the default still should stand. And again, there was some dispute in the briefs. I know the court's read it on the standard of review. I think it's very clear that the standard of review is an abuse of discretion. I think it's clear from the detailed orders that Chancellor Thurman signed that he considered the proper legal principles, that he looked at the proper range of alternatives, and he reached a logical conclusion. And as the Supreme Court said in Harmon, our appellate court should not second-guess trial court decisions if reasonable minds can differ. So even if Your Honors felt that perhaps the default was a little bit extreme or perhaps something else should have happened, I don't think that there's any fair argument that Chancellor Thurman didn't consider the appropriate factors and that it's within the range of alternatives, and our appellate courts should give deference to those kinds of decisions. With respect to the subsequent proceedings and the damage hearing, this court, as recently as 2023, in the Uree case, Y-O-U-R-E-E, said that the way that you handle these defaults is that the default admits all facts and all fair inferences from the complaint. This is a fairly lengthy complaint. I think it has maybe 65 to 75 paragraph allegations. It has 9 different counts. All of those facts and fair inferences are deemed to be admitted. Another case from this court, the Sherritt case, says that you also have to deem admitted any conclusions of fact to be drawn. And so the hearing, based on this case law and based on the Supreme Court's case in Patterson, says that the hearing is confined to the amount of damages. This court in 2017 had a reported case called Tennyson Brothers. It was a 45-page long case. It was very, very lengthy. It went through a lot of different issues, but it did address what the proof was necessary at a damages hearing, and it also rejected some of these causation arguments that the appellant has made in his brief. It quoted from an 1870 Tennessee Supreme Court case called Warren. And in that case, the Supreme Court held, and I think it's still good law because it's consistent with all of these other cases, and it's cited by this court in its 2017 reported case, quoted actually, the only proof needed at the damages hearing was the value of what was taken. And so we took that to heart, and we tried to streamline this hearing so as not to open the door to relitigate liability. Of course, the appellant wanted to relitigate liability, very much so. The argument in the brief really turns all on liability arguments. On page 71 of the brief, the appellant said specifically that all of the excluded testimony that's in dispute here, quote, related to whether any fraudulent or oppressive conduct happened and about Mr. Beasley's relationship with the defendant. And that is just re-arguing liability under the guise of causation, and that's not appropriate. Likewise, on page 66 and 67 of the appellant's brief, he talks about the proof that they would have introduced, which is this, quote, high-quality care that Mr. Beasley allegedly provided to Ms. Koczwara that the opposing counsel discussed in his principal argument. Her actual intent with regard to the disposition of her estate and how this supposed 2020 will came to be. Those are all arguments of liability. Because of the confessed judgment by default, it's deemed admitted that there was undue influence. It's deemed admitted that there was conversion. It's deemed admitted that Ms. Koczwara was a victim of fraudulent and negligent misrepresentation. It's deemed admitted that she was abused as an elder in violation of the Adult Protection Act. And so those arguments don't have any merit, and they're not appropriate to raise at a damages hearing. I think this court's case of Tennyson forecloses that. Finally, the last thing I would say is that this is a court of equity. The Chancery Court is obligated to try and resolve all issues that are in dispute. The Chancery Court did that. It took some time. Once my friend here got involved, they raised every issue and threw up every objection they possibly could. They've got 24 issues on appeal here. I don't think that has any merit. I think this case is very straightforward, quite frankly, and that the judgment should be affirmed. But the strategy here by the appellant is to try and drag this out and raise every issue they can and hoping that something will stick in order to convince you all to reverse it and go back to 2 or 3 more years in the trial court. This gentleman, her hairdresser, is still living in the house today. He's not paying any rent. Something could happen to that at any time. The Chancery Court's ordered that it be sold as part of the judgment, but they filed a motion to stay pending appeal. And while I opposed that aggressively, the trial court granted that with some conditions, and that's where we are today.
Has bond been set?
The trial court did not really require a bond because it was the house, and the trial court said as long as it was insured, and I don't know that it is. I haven't been provided any evidence, but as long as that's the case, he wasn't going to sell the house out from under it. Thank you, Your Honor.
Mr. Rader. Mr. Fincher, your rebuttal.
Thank you, Your Honor. I appreciate the compliments from my friend. It's always good to do battle with him. I mean, he stood right here, stared 24 glaring errors in the face and said they didn't matter. They do matter. In particular, number one, what you didn't hear is any claim of prejudice if the default is set aside to them. And that's because there isn't any. This is like a tree falling in the forest and nobody heard it. Yeah, it was late, but it's still early in the case. No depositions were taken. discovery hadn't been exchanged. That very day that the default was granted, there was a motion to compel. My friend brought me a box of documents to court that day very graciously, then got the default. I still have the documents. But there was no prejudice. The case can be done. He mentioned that we want to delay this out. We want to have our day in court. We haven't had a fair day in court yet to produce facts. We've had fair hearings on procedural matters, but we haven't been able to present the witnesses and the truth and the facts that matter. And I submit to you that while cognizant of the procedural importance of these things, all of them, the need to file an answer, the need to follow Rule 602, and the need to have the will admitted to probate, I think they all pale in comparison, procedure pales in comparison to facts, proof, and what's just. Now, if we produce the facts and we have a hearing and we are ruled wrong, that's a very different place than where we are today. Where we are today is with good facts, with good witnesses, with strong defense that was amply in the record before the initial grant of default, and we still were defaulted. And procedure was vaulted over fairness.
What do you say in response to the Adult Protection Act that says the accused in the alleged abuse lacks standing?
Well, okay, if you look at this immediate moment in time, he's correct because he got to the courthouse first. So if someone goes with a will, no matter how old, no matter how times revoked, and they get appointed first, because they don't give notice, right? He didn't give notice to Mr. Beasley, and he gets appointed, then they have standing for that moment. What happens when we get a fair hearing on the 2020 will? Now, maybe his substantive points carry the day, but maybe they don't. The fact is we haven't had that. What this court has in its record is a validly executed will subsequent to the 2016 will that knocks them out of it, which, if everything goes as it's supposed to, will result in Mr. Beasley having the letters testamentary, not them, which at that point, he then has the decision on whether to sue himself or not. Now, they're not without remedy. They can contest the will. They can say that they can come back and they can try to argue it. If I may, I know it's a red light. One thing, the chancellor did use the wrong legal standard. He used the Discover Bank case, which applies to motions to set aside default judgments, not initial grants of summary judgment. I addressed my contention that it's a de novo standard in my brief.
All right. Thank you, Mr. Fincher
Thank you,
and
gentlemen.
Mr. Rader, for your arguments. We'll take this case under advisement.
Thank you, sir.
And both of you have a safe drive back to Cookville.
I'll see y'all this afternoon. I've got another one today.
Oh, my goodness.
I'm defending the wise chancellor in that.
Well, the three of us may try to recuse ourselves, Mr. Rader. Would you like, Mr. Rader, would you like to be a special judge this afternoon?
That'd be a delight.
Okay, very good.
I object.
All right, call the next case, please.
Tammy Hudson Boone versus Paul Dale Boone.